Good morning, everyone. Today, we will start our new chapter of Civics, the Indian Constitution, chapter number 1. Here are the synopses of this chapter. Introduction, Importance of Constitution, Drafting the Indian Constitution, Features of our Constitution, Preamble, Separation of Powers, Universal Adult Franchise, and at last, Fundamental Rights. So, student, all of you know about our rights and fundamental rights. But who give us these rights? Yes, it is our Indian Constitution. So many more question arises here. When was it formed? How was it formed? Why was it formed? So, students, let's find out more about the Indian Constitution. The Constitution of India is the supreme law. It frames fundamental political principles, procedures, rights, powers, and duties of the government. It imparts constitutional supremacy and not parliamentary supremacy, as it is not created by the parliament but by a constituent assembly and adopted by its people, with a declaration in its preamble. It is also the world's longest constitution. At its commencement, it had 395 articles in 22 parts and 8 schedules. It consists of approximately 1,45,000 words, making it the second largest active constitution in the world. Currently, it has a preamble which is bifurcated in 25 parts with 12 schedules, 5 appendices, 448 articles and 108 amendments. The Constitution of India was adopted on 26th of November in the year 1949. However, it came to effect on 26 January 1950. On 26 January 1950, this is very important day for our whole nation. That's why we celebrated as the Republic Day of India. It was adopted by the Constitution Assembly, and the drafting chairman of the committee was Dr. B.R. Ambedkar, who was widely considered to be the architect of the Indian Constitution. After the adoption of the Constitution, the Union of India became the contemporary and modern Republic of India. So my first question is, who introduced Indian Constitution? Answer is Dr. Bhim Rao Ambedkar. He was the chairman of the drafting committee, which is widely considered to be its chief architect. It imparted constitutional supremacy and was created by Constituent Assembly rather than Parliament, and it was adopted by its people with a declaration in its preamble. Again, my next question is, who gave the idea of Constitution of India? Again, the answer is Dr. Bhim Rao Ambedkar was appointed the head of the drafting committee on August 28, 1947, with one objective: to draft a permanent and organized constitution. Again, my next topic is the importance of Constitution. Why is the Constitution important? Here are some reasons behind this. A country is run by the government, judicial body, its people, and the most importantly by the Constitution. The Constitution serves as the backbone of the country. Without it, the law and jurisdiction will not hold up and fall apart in no time. But they are meant to stand strong. The Constitution is the part of fundamental regulation and principle according to which the country, state, and its people are supposed to work. The term Constitution got its name as the word Constitution means accumulation and gathering of various aspects. Similarly, we can say that the Constitution we are talking about also is an accumulation of many things that make up the organization of the legal body of any nation. All the rules and principles that are to be established are worked up and wrote down in one place, making all the things one single crafted manuscript. The document formed after this whole procedure is known as the Constitution. But despite of all of this information, we still have a question in our mind that why is the Constitution important? So let's discuss further on the topic. The Constitution is something that every country has in its possession, and all constitutions around the world are unique in their way, but share the same objective, which is to make sure that there remains stability in the nation. The Constitution has much verbal meaning, and all of them denote the sense of constructing or building up to something. One might wonder if this is how the documents of principle got its name. How does a constitution help in the working of a nation? One of the major problems of any country is the distribution of power, something or sometime leak from here and there, causing civil uproars and various issues that lead to the economic and social downfall of the country. Thus, only thing that the Constitution of India concern about most is the power distribution. A constitution is a set for the countries to develop successfully, and they added improvement in the constitution will thrive up to this. Thanks to the constitution, the power of the governmental bodies flow in a certain path. As the Indian constitution, it distributes the powers horizontally throughout the three major institutional bodies, that is, executive, judiciary and legislature. So here are the important steps involved in the execution. Any bill is first presented in the executive houses of the country as far the case of India, in particularly according to the two houses, that is Lok Sabha and the Rajya Sabha. Once the bill gets the approval of two-thirds of the members of both the houses, it is passed to the parliament. Usually, the president signs the document, but in some cases, if he or she does not feel like passing it at the time, they have the power to send it back with a suitable reason. Next topic, drafting the Indian Constitution. Most of the Indian subcontinent was under British rule from 1857 to 1947. From 1947 to 1950, the same legislation continued to be implemented as India was a dominion of Britain for these 3 years, as each princely state was convinced by Sardar Vallabhbhai Patel and V.P. Menon to sign the Articles of Integration with India, and the British government continued to be responsible for the extremely security of the country. Thus, the Constitution of India repealed the Indian Independence Act 1947 and Government of India Act 1935. When it became effective on 26 January 1950, India ceased to be dominion of the British Crown and became a secular democratic republic with the Constitution. Here are some articles: 5, 6, 7, 8, 9, 60, 324, 366, 367, Article 379, Article 380, 388, 391, 392, 393 and 394 of the Constitution came into force on 26 November 1949, and the remaining articles became effective on 26 January 1950. The Constitution was drawn from a number of sources, mindful of India's need and condition. Its framers borrowed features of previous legislation such as the Government of India Act 1858, the Indian Council Act 1861, 1892 and 1909, the Government of India Act 1919 and 1935, and the Indian Independence Act 1947. It later on, which led to the creation of India and Pakistan, divided the former Constituent Assembly in two. Each new assembly had secular power to draft and enact a new constitution for the separate state. Let's talking about Constituent Assembly. The Constitution was drafted by the Constituent Assembly, which was elected by elected members of the provincial assemblies. The 389-member assembly, reduced to 299 after the partition of India, took almost 3 years to draft the constitution, holding 11 sessions over a 165-day period. Dr. Bhimrao Ambedkar was a wise constitutional expert. He had studied the constitution of about 60 countries. Dr. Ambedkar is recognized as the father of Indian Constitution. In the Constitution Assembly, a member of the drafting committee. In this whole session, Mr. T. Krishnamachari said, Mr. President, sir, I am one of those in the House who have listened to Dr. Ambedkar very carefully. I am aware of the amount of work and enthusiasm that he has brought to bear on the work of drafting this constitution. At the same time, I do realize that that amount of attention that was necessary for the purpose of drafting constitution so important to us at this moment, which has not been given to it by the drafting committee. Here are some important information about the formation of Constitution of India. 8 December 1946, the formation of the Constitution Assembly in accordance with French practice. On 9th December 1946, the first meeting was held in the Constitution Hall. Third one, 11 December 1946, the Assembly appointed Rajendra Prasad as its president and Mr. H.C. Mukherjee as its vice chairman and B.N. Rao as constitutional legal advisor. Initially 389 members in total, which declined to 299 after partition. Out of 389 members, 292 were from government provinces, 4 from chief commissioner provinces and 93 from princely state. On 13 December 1946, an objective resolution was presented by Pandit Jawaharlal Nehru, the former Prime Minister, laying down the underlying principle of the Constitution. This later became the preamble of the Constitution. On 22nd January 1947, objective resolution adopted. Again on 22nd July 1947, national flag adopted. On 15th August 1947, achieved independence. India split into the Dominion of India and become the independent country. On 16 July 1948, along with Harendra Kumar Mukherjee and V.T. Krishnamachari, was also elected as second vice president of Constituent Assembly. On 26 November 1949, the Constitution of India was passed and adopted by the Assembly. On 24 January 1950, last meeting of the Constitution Assembly, and on 26 January 1950, we already know it very well, the Constitution became into force. Features of Indian Constitution. The salient features of Indian Constitution are as follows. Single constitution for both union and state. India has a single constitution for union and all the state. The constitution promotes the unity and convergence of the ideals of nationalism. Second point, sources of the constitution. The Indian Constitution has borrowed provision from various countries and modified them according to the suitability and requirements of the country. The structural part of the Constitution of India has been derived from the Government of India Act 1935. Third point, flexibility. The Constitution of India is neither rigid nor flexible. A rigid constitution means that special procedures are required for its amendment, whereas flexible constitution is one in which the constitution can be amended easily. Secular state. The term secular state means that all the religions present in India get equal protection and support from the state. Single citizenship. Constitution of India provides for single citizenship to every individual in the country. No state in India can discriminate against an individual of another state. Moreover, in India, an individual has the right to move to any part of the country or live anywhere in the territory of India except certain places. Next point, integrated and independent judiciary. The Constitution of India provides for an integrated and independent judicial system. The Supreme Court is the highest court of India with authority over all the other courts in India, followed by High Court, District Court and Lower Court. Next point, directive principles of state policy. Article 36 to 50 of the Constitution mention the directive principle of the state policy. These are non-justifiable in nature and are broadly classified into socialistic intellectual procedures. Fundamental duties. These were added to the Constitution by 42 Constitution Amendment Act on 1976. A new part 4A was created for the purpose and 10 duties were incorporated under Article 51A. The provision reminds the citizen that while enjoying rights, they should also perform their duties. And at last, universal adult franchise. In India, who is above the age of 18 years has right to vote without any discrimination on the ground of caste, race, religion, gender, literacy, etc. Our next topic is preamble. The preamble to the Constitution of India is a brief introductory statement that set out guidelines which guide the people of the nation and to present the principle of the Indian Constitution and to indicate the source from which the documents derives its authority. The actual meaning is to conclude the hopes and aspirations of the people are described in it. The preamble can be referred to as the preface, which highlights the entire Constitution, which was adopted on 26 November 1949 by the Constituent Assembly and came into effect on 26 January 1950. The main objectives. The Supreme Court of India originally stated in the presidential reference that the preamble is not an integral part of the Indian Constitution and therefore it is not enforceable in a court of law. However, the same court in the year 1973 overruled earlier decision and recognized that the preamble may be used to interpret ambiguous areas of the Constitution where differing interpretations present themselves. In the year 1995 case of Union Government versus LIC of India, the Supreme Court once again held that preamble is an integral part of the Indian Constitution. As originally enacted, the preamble described the state as a secular democratic republic to which the terms secular and socialist were later passed by a captive parliament during the emergency India into 42nd Amendment Act. The preamble, along with other process, were decorated by the renowned painter Mr. Bihar Ram Manohar Sinha of Jabalpur, who was at Shantiniketan with Acharya Nandalal Bose at that time. Nandalal Bose endorsed Bihar Ram Manohar Sinha artwork without any alteration whatsoever. As such, the page bears creates a new format, and also we can say that the calligraphy was done by the Prem Bihari Narayan Raizada. Our next topic is separation of powers. Separation of powers are also classified into legislature, judiciary, and executive. Legislature means it is a particular branch of government which is responsible for enacting the laws of the state and appropriating the money necessary to operate the government system. Executive means it is responsible for implementing and administrating the public policy enacted and funded by the legislative branch. And at last, judiciary. Judiciary branch is responsible for interpreting the constitution and laws and also applying their interpretation to controversies brought before it. Our next topic is UAF. The full form of UAF means Universal Adult Franchise. It means that the right to vote should be given to all citizens or all particular people, those who are 18 or above in age, without any discrimination of caste, creed, color, religion or gender. Our next topic is fundamental rights. The Constitution guarantee has 6 fundamental rights to Indian citizens which are as follows, right to equality, right to freedom, right against exploitation, right to freedom of religion, right to cultural and educational, right to constitutional remedies. First is right to equality. Right to equality is one of the chief guarantee of the Indian Constitution. It is embodied in Article 14 to 18, which collectively encompasses the general principle of equality before law and non-discrimination, and there is no any other power given to any caste. Or we can say this, everyone is equal in the eyes of law. Next point, right to freedom. Right to freedom is conveyed in Article 19 to Article 22 with the view of guaranteeing individual rights that were considered vital by the framework of Constitution, and this article also includes certain restrictions that may impose by the state on individual liberty under specified condition. Or we can say this, under the Indian Constitution, all citizens have the right to freedom of speech and expression, assembly in a peaceful manner, to form association, union and cooperative societies, move freely throughout the country, reside in any part of the country. Next point, right against exploitation. Once the right to liberty and equality is granted, it follows that every citizen has a right not to be exploited. Still, the Constitution makers throughout it is necessary to write down under certain clear provision to prevent exploitation of the weaker section of the society. The Constitution mentions three specific evils and declare this illegal. First, the Constitution prohibits human trafficking, which means the selling and buying of human beings usually. Second point, our Constitution also prohibits forced labor or beggar in any form. Third, the Constitution prohibits child labor. No one can employ a child below the age of 14. Next point, right to freedom of religion. It is based on the idea that the country is concerned only with relation among human beings. India is a secular state. A secular state is one that does not establish any one religion as official religion. In India, no privilege or favor is provided to any particular religion. Cultural and educational rights. The working of democracy give power to majority. Thus, it is the language, culture and religion of minority that need special protection. Otherwise, they may get neglected or undermined under the impact of language, religion, culture of the majority. The following culture and educational rights for minority are also specified by our Indian Constitution. Any section of citizen with a distinct language or culture have right to conserve it. Admission to any educational institute mentioned by government or receiving government aid cannot be denied to any citizen on the grounds of religion or language. All minorities have the right to establish and administer educational institute of their choice. And at last, right to constitutional remedies. The fundamental rights in the Constitution are important because they are enforceable by law. We have a right to seek the enforcement of these mentioned rights. This is called right to constitutional remedies. This right makes other rights effective. When any of the fundamental rights are violated, then citizen can directly approach the Supreme Court or the High Court. Both courts have the power to grant or to create any type of law on the basis of enforcement. That's why Dr. B.R. Ambedkar called the right to constitutional remedy the heart and soul of our Indian Constitution. And its last topic is related to fundamental rights, directive principle of the state policy. Directive principle of the state policy aim to create social and economic conditions under which the citizen can lead a good life. This also aims to establish social and economic democracy through a welfare state. Besides, all executive agencies of union and state should also be guided by this principle. So my question is, how many directive principles of state policy are there? Answer is, in part 4 of the Indian Constitution contain 20 directive principles of the state policy, and these are listed from Article 36 to Article 51. Again, my next question is directive principle of state policy justifiable? The basic objective of the directive principle is to create a welfare state. The fundamental rights are justifiable, that is, a person can approach the court on their behalf. The directive principles are justifiable and also cannot approach to the court if they are not enforced by the state. What are the three types of directive principles? The Constitution of India does not formally classify the directive principle of state policy, but for betterment, understanding, and on the basis of content and direction, they can be classified into three categories: socialist, secular, and liberal. Thank you everyone. Have a nice day.